anyway, at Restore Justice, we work on state level policy reforms that impact people serving extreme sentences. And we also emphasize working with their families, which many of you know. Next. Uptown Peoples, I'm just going to tell you, over 40 years, they're dedicated to supporting the struggle of poor and working people, which you can all read that. They believe everyone has a fundamental human right, which deserves protection, including those people in prison and people experiencing homelessness, people who are disabled, and tenants. Next. We love them. Here's our agenda. We're going to go through our housekeeping, which I'll do in a minute. We'll do some intros real quick. Then we'll get right to the good part, Alan Mills, and then maybe some next steps. August, I can't believe it. Okay.
You're not going to read all that.
Now, I'm not going to read all this. I'm just going to tell you, especially the 1979 part. Alan's been around the block a few times. Anyone who's fought for anything inside the Department of Corrections has probably seen Alan visiting somewhere or heard about a class action lawsuit they've had at Uptown. Like I said, we're just so grateful that he was able to come on the call. And they currently have 5 pending class action suits, which regarding prisoners' civil rights. And there's one thing I just want to add to that is they spearheaded during COVID, when everyone was getting those rebates from the income tax thing. Uptown spearheaded making sure every single incarcerated person had the form to fill out so that they could get that money. So that was pretty awesome. So yay. Okay, next. And our housekeeping, pretty easy. We're going to ask you to go on chat and introduce yourself and what brought you to the call. And we're going to also ask you in chat to post questions. We have Lizzie, raise your hand if everyone can see you. And James, I saw also from the Restore Justice staff, and they will be monitoring the chat and will get your questions asked as best they can. And we are going to ask everyone to stay on mute for the benefit of everyone. And again, I'm just going to say that the meeting is being recorded, just so you all know, and you all will receive a copy of the recording along with the slides. So next, I think I'm done, right? Ta-da! And now, with no further ado, Alan.
Okay, so as Julie says, we have several class action cases pending. 2 of them are particularly relevant to this case. One involves a class action case saying that the Department of Corrections does not provide meaningful care to people who have any variety of medical issues, and the other is the same sort of thing, except it is for mental health issues. So as a result of that, we've learned a lot about the structure of the IDOC, as well as, and part of what I'm going to talk about today is some of the limitations of the law in terms of what restrains our ability to get remedies. So I don't want anybody to walk away from this thinking that if you just call a lawyer, they have a magic wand and get your loved one help inside prison. Unfortunately, we never had a magic wand, and to the extent we have ever had one, the courts have taken it away. So I want to start off, though, by talking about the structure of the system as a whole. So you kind of have a better idea of who the players are. It often looks like a sort of black box. You know that there are doctors in there, and there's nurses, and there's a bunch of other people. So let's go to the next slide, and that kind of lays out the overall, the way the system is set up. So Illinois, like many other states, has decided that it's not going to hire doctors or other medical professionals itself. Instead, it contracts with a corporation, a for-profit corporation called Wexford Health Sources, Inc. That is a corporation that is incorporated in Florida, has its headquarters in Pittsburgh, has contracts all over the country, mostly not with states. There's a couple of states in addition to Illinois that has contracts with, but mostly with county jails. And there are dozens of them all over the country. Wexford is one of the 2 or 3 big conglomerate healthcare providers that contract and provide the vast majority of the medical care in many states and counties. So Wexford itself employs a whole bunch of people. There's a bunch of people, administrative types in Pittsburgh, but in Illinois, there's a state director, and then it has divided Illinois into 3 regions, north, central, and south. Each of those regions has a regional medical director, and then every prison has a doctor who is identified as a medical director for the doctor. In some of the smaller prisons, that may be the only doctor in the prison. Some of the larger prisons, at least in theory, will have 2 or 3 or more doctors working underneath the medical director. But the medical director is the one who's again, in theory, responsible for ensuring that all of the medical care that's given in a prison is adequate, is up to snuff, meets the standards of the medical profession. And then underneath the medical director are a wide variety of other people, doctors, various licensing nurses. So there's registered nurses, there's licensed practical nurses, and 2 or 3 others that I can't remember, never remember the name of, or the initials for. So that's who is in 99% of the time going to be providing actual health care to your loved ones inside, or to any prisoner in the state of Illinois in the IDOC. On the state side, there's a parallel sort of system. So of course, at the top, there's a director, and then there's a deputy director of programs. Reporting to the deputy director of programs is the IDOC medical director. Now that's an actual doctor who's going to provide care to, or is going to oversee the medical system in the entire state. Just like there's 3 different regions for IDOC. For Wexford, there's also the same 3 regions for the state employees, and there's 3 different regional medical directors, again, north, central, and south. Now, every prison then has someone called a healthcare unit administrator. Many prisoners think they're the ones that call the shots because they're sort of in charge of the healthcare system, but they actually don't have any authority to order any Wexford person to do anything, because Wexford has its own chain of command, and the healthcare unit administrator, obviously, from this chart, is in a different chain of command. The healthcare unit administrator's main job is to make sure that Wexford is actually complying with the contract. That is, they have the right number of dentists there, they have the right number of doctors there, the right number of nurses there, et cetera. They're also the ones that deal with grievances. So they're sort of the interface between the medical side and the security side. Generally, their licensure is as a nurse, but they don't generally provide any direct care at all. Many prisons have a pharmacy technician that is hired, that is employed by the Illinois Department of Corrections. They're the ones that are responsible for ordering and sorting out the medications that are given to prisoners daily or weekly or whatever they're handed out. And then there are a couple of prisons that still employ state-employed nurses. These are sort of a leftover from years ago when all the nurses were employees of the Illinois Department of Corrections. There are still a few of them left. They may be mixed in with Wexford nurses in the same prison, or they tried pretty much to separate them out so that some prisons have state nurses and some prisons have Wexford nurses. So nurses may be employed by their side. So that's the main people that you're going to be dealing with inside the prison. Now, if your loved one ever needs to be sent outside of the prison, then that is going to require a whole different set of providers, and they can be anybody on the outside. It could be a orthopedic surgeon, it could be an eye doctor, it could simply be somebody running an MRI, it could be a foot doctor, it could be any kind of thing. The vast majority of those outside providers are at the University of Illinois in Chicago hospital system, but by no means all. Lots and lots of local providers that work with the IDOC or work really with Wexford. Wexford contracts with them all. And there's also then a national pharmacy, Banfield, which is what actually provides the drugs. This pharmacy tech will fill out at the end of every day a list of all the medications that have been prescribed by the doctor, send it off to Banfield, and then the next day or two, those medications will be delivered back to the prison, and the pharmacy tech then divides them up, and ultimately they make their way to the prison. But they don't just go to the local Walgreens and pick up aspirins. They use this wholesaler national. Okay, so you can go to the next slide now. So how do prisoners get to see all of these people? Well, the general procedure is called sick call. You literally fill out a form saying, I want to go see the medical people because X, whatever the problem is. You fill that out, you put it in a box or hand it to a guard or hand it to somebody who's coming around your counselor, all kinds of ways it can get there. Those all go to the healthcare unit. And then usually it's the healthcare unit administrator who looks at all those requests that came in and prioritizes. It's like a triage in the emergency room to figure out some of those people are desperate, they need to get seen right away. Others of them have some minor things that can wait. So they make up a priority list, give that back to the security staff, and the security staff is responsible then for bringing those people over the following day. Of course, not necessarily everybody gets on the list, and not necessarily everybody who's on that list actually makes it over. Guards are notorious for, hey, I got busy that day, I got pulled off to do, an escort duty or take somebody to the hospital or go to the visitor center or whatever, and I didn't have time to move people. So not everybody who's on that list necessarily makes it, and everybody put in a slick call slip may not get seen the next day at all. So when you get over to the healthcare unit, escorted by a guard, you don't see a doctor, you see a nurse. Now, under state law, nurses are not allowed to make diagnosis and prescribe treatment. What they can do, however, is follow what are known as protocols. So Wexford has a big book which has a list of various things and what you tell people. So if somebody comes in and says, I got a bad back, the nurse looks at a little book and it says, okay, if somebody comes in with a bad back, you give them 2 Tylenol, they go back to their cell, and if it doesn't get better, to come back on sick call again. So that's what happens. So then you go back to your cell, you take your Tylenol. A few days later, your back isn't getting any better, so you fill out the slip call again, goes back to the healthcare unit administrator, go back on the list, you eventually get back over there. The second time, you also don't see a doctor. You're going to see a nurse again. The nurse again looks at her little protocols and it says, okay, somebody with a bad back. Step 2, I gave them the Tylenol, that doesn't work. Step 2 is, now I got a sheet of paper which has exercises on it. I'm going to give you physical therapy exercises. Like go to your cell and you bend over, or you do this kind of sit up, or what, I don't know what they are for bad backs, but it lists and it shows little pictures of the 10 different exercises you can do, and says if that doesn't work, you come back. If that doesn't work, then you fill out the slip again. You go to the slip makes its way to the healthcare unit. The healthcare unit makes the priority list. They give it security, and hopefully you get taken over a third time. And usually the third time you're going to see a doctor. So finally, you get a doctor who can say, yes, this is a diagnosis, these are the tests we have to run, etc. So many prisoners have complained all the time that it took me 3 trips over there before I could actually see a doctor. Now, up until maybe 3-4 years ago, maybe it was right before the pandemic, each of those trips to the healthcare unit cost you $5 copay, which on the outside doesn't sound like a lot, but remember, state pay inside is $10 a month. So you're talking about half of your salary for each month is going to go to just being able to see a nurse and not really get a sheet of paper which says do exercises. Because of our lawsuit and the federal court monitor repeatedly saying this system makes no sense whatsoever, all it does is discourage people from going to see people when they have a small problem and wait until they have a big problem, which is hard to solve, that it actually inflicts totally unnecessary pain on prisoners and frankly probably costs the IDOC more money. So they got rid of the $5 copay. So there's no more copays. And I don't want to say that you have to go through this 3-step process all of the time. Clearly, if you show up at the healthcare unit with, to pick a silly example, bones sticking out of your arm because it's broken, they're not going to say, take 2 Tylenol and come back. They're going to whip you into a doctor, and the doctor is going to say, yes, this person needs the emergency treatment, call 911 or whatever the local equivalent is, and have you taken to a hospital so your bone can get set. So I'm not saying that happens every time, but I am saying that happens almost all of the time. Lots and lots of people have to go through this whole rigmarole and that can take a while. It can take a couple months before you actually get to see a doctor, going through this process over and over again. Let's go to the next slide. So let's say you get to the doctor finally, the doctor says, well, you need some tests on the outside, or you need an actual operation, or you need to see a specialist. Well, in the past, and I'm talking about until about 2 years ago, that too required multiple step process. So the treating doctor had to make that request of the on-site medical director, which may or may not be the same person. The on-site medical director had to send a fax over to Pittsburgh or somebody higher up in Wexford, not in the prison, and go through what's called the utilization or collegial review. And basically that meant they picked up the phone and they talked to the on-site medical director saying, hey, do we really need to do this? And almost never would they say no, but rather they would come up with what are known as alternative courses of treatment. So other things that they want to do before sending you out to the actual provider that the doctor said you needed. It could be sending you back for a second opinion. So for example, there was a really horrible case in Central Illinois where a prisoner had some problem with his eye. The doctor inside says, yeah, I'm not an eye doctor. You need to go see somebody on the outside, an ophthalmologist. Instead, Wexford said, well, let's not send it to an ophthalmologist yet. Let's send it to an optometrist. Send it to an optometrist. The optometrist said, no, they really need to go see an ophthalmologist. Went back again through that whole loop again. The second time utilization review said, well, let's get a second opinion. I don't think it really needs to go to an ophthalmologist. I think an optometrist can do it. They did that 3 times. Went out then finally on the 4th time to an ophthalmologist. The ophthalmologist says, yeah, he has a really serious problem. He needs to see a surgeon. And they said, well, no, we need a second opinion. Sent it to a second ophthalmologist and a 3rd ophthalmologist. All of this took over a year. Finally got to the eye surgeon. The eye surgeon said, sorry, his eye is so bad, you can't save it anymore. He's blind for life. So he sued and got a fair amount of money. But that's just one example of how this kind of loop that people were in could really lead to really terrible results. It could also be like sending them out for more testing, or it could be trying some more conservative treatments before, for example, you try surgery. So a couple of years ago, again, as part of our lawsuit, the monitor said, again, this is ridiculous. It, first of all, just slows down getting people the treatment they need and really causes unnecessary pain and suffering. And perhaps even more importantly, it dissuades doctors who don't have the knowledge that they need from seeking help, because they have to go through this long rigmarole in order to actually talk to a specialist and find out what's going on. So somebody, for example, as a doctor who doesn't know much about cancer, can't actually send somebody out for a cancer specialist whose name I'm blocking on. Anyway, as a cancer specialist, oncologist. Yep, got it. Took me a minute. Send it out to an oncologist and would like to know whether the on-site doctor would really like to know, hey, are these symptoms I'm seeing? They kind of look like they're cancer to me, but I'm not really sure. He really ought to go see a specialist. But if you have to go through this whole rigmarole, you're like, well, let's not send it to a specialist yet, because I know I'm going to have to go through all this stuff. I'll try some stuff like giving him pain meds. I'll give him Tylenol. I dealt with a prisoner down at TAMS when the Supermax prison was open, who in fact had a positive prostate antigen test, whatever that's, I think that's the PSA test, saying he had potentially had prostate cancer, began to have lots of pain. The inside doctor just kept giving him Tylenol. And then when the pain got worse, he said, well, you're getting older, meaning he was like 45. This is just arthritis. It comes with being older. And by the time I finally was able to intervene and get him to an oncologist, he had cancer, which had in fact metastasized. And even though he started chemotherapy right away when he went out, he died a couple months later. So this sort of around and around like this is absolutely deadly sometimes. So at least in theory, the IDOC agreed to outlaw this. So there's no more of this loop. However, the treating doctors in the prisons still need authorization from Wexford because somebody has to pay these outside people. So they need approval for payment. So they now call it that they consult with the outside people in order to get payment for these things. So it's not a formal process anymore, but there is still the possibility of Wexford saying, no, we're not going to pay for it. Try something else. So it's certainly improved. It's made it easier to go out to outside providers, but it hasn't completely solved the problem. Doctors on site still don't have the right just to send you out because they want to. And that is all also true on the outside. I mean, anybody who's an HMO knows that often your treating physician can prescribe something. HMO says, no, we're not paying for it. And then you have a big fight. So it's not that different. But the big difference is, of course, if you have an HMO through your employer and it's really bad HMO, then all the employees can say to the employer, hey, we need a different plan. IDOC is never going to get a different plan because prisoners aren't satisfied. So prisoners don't have the same sort of bargaining power or choices that employers on the outside do. So it's sort of like the world's worst HMO where you can't get out of it, but you're stuck with it. So that's kind of how this system works. Now, let's try the next slide. The IDOC is also very behind the world in any kind of electronics. The Department of Corrections only like 6 or 7 years ago made the big jump from what was known as COBOL to what we all now know as Windows in their computer operating system. COBOL is the system they had back in the 1970s when computers were buildings. It's what I learned in like 1976 when I was in college, and you had to use punch cards. It was a long time ago, and that's the system the IDOC used until about maybe 6 to 10 years ago. Medical records are still handwritten. Even though almost all the entire world has switched to electronic medical records, I don't remember the last time I went to a doctor and he sat there and filled out things by hand. There always was a little computer in front of them. The Department of Corrections still uses handwritten records. And they always use the same format. It's called the SOAP format. So it's subjective, objective, assessment, and plan. Subjective is literally, what does the person say? In this case, it was really simple. He said, good morning. So they wrote that down. What's the objective? What did they actually do? Well, in this case, they escorted him to a room where he had his blood sugar checked, checked, and they gave him insulin. What's the assessment? Is that he's an insulin dependent diabetic. That's all it says. What's the plan? Continue to do the same thing every day, monitor it every day, and give him insulin as ordered. So in this case, it was really simple, but often it can be much more complex. But in every single case, there will be those 4 entries. It should be for every contact between the prisoner and somebody on the medical staff should generate a handwritten note that looks like this. Now, what's the problem with handwritten notes? Well, there's 2. One is often they're hard to read. Second of all, it's really easy to lose pieces of paper that we've had a couple of occasions where people have actually written down the truth, like I got beat up by guards, and somebody looks at it and says, oh no, we can't write that down. So all of a sudden that piece of paper will disappear and a new one will go in the file. In the case I was doing, it was substituted to I had a fight instead of I got beat up by guards. So what's written down, you have to keep in mind that what's written down in medical records is only one person's version of what happened. These are records that are done by the medical staff. They are not like objective records at all. They're one party, in this case, Wexford's version of what happened. So we have to remember that they're not entitled to any bigger weight than what your own loved one says happened. And they are not necessarily accurate because often, I think somebody just put in the chat, often there's an incentive not to write down stuff that the prisoner says. And we'll see why that incentive is in many ways induced by the law. So let me talk a little bit about the problems in Illinois. So give me the next slide. Before we started our lawsuit, the amount of spending per prisoner in Illinois was 50 among the 50th states. So this is per prisoner. And not by just a tiny little bit. This is, I've put on the left here, some other states. At the time, Illinois was spending about $3,500 per prisoner per year. Michigan spent a little more than twice that. California spent about 5 times what we spend. And you have to remember, California is the state where the United States Supreme Court held that their medical care was so bad, it could not be fixed. And the only solution was to let people go home. So we only spend about 1/5 of what the totally unconstitutional and unfixable California system did. Now, I don't want to say that the cost of living is the same because there's no question it's more expensive than California than it is in Illinois, but it's not 5 times as expensive than California as it is in Illinois. We got what we paid for. As a result of our litigation, we're probably, I haven't seen a current study, but my guesstimation is we're probably fought our way up to probably 35th in that general vicinity among the 50 states. So an improvement, no question, we're spending more money, but we're nowhere near where we need to be in order to actually provide medical care. Let's go to the next slide. And if you look at mental health care, there's some numbers out there that are clear. So when we were litigating this case, one of the early things the court said is, IDOC, you come up with a number. How many staff do you need in order to actually provide mental health care? Not medical at this point, just mental health care to all the prisoners who need it in Illinois. And the Department of Corrections came up with 516. We thought that was low, but we were willing to live with 516. The court said, well, I'm not going to make you hire all 516. We're going to set a lower court order at 451. Okay, but their actual staffing was 351. So only 3/5 of what they said they needed. And that remains true today. They haven't done any better than they did back in 2019 when we had this case going at that rate. On the medical side, it's even worse. There's about a 50% vacancy rate among doctors, nurses, and all of the other medical people on the physical health side in the Department of Corrections. So as a result, you often have one doctor who covers maybe 3 or 4 different prisons, particularly in Southern Illinois. There's one doctor who is, in theory, responsible for 5 different prisons. He's the medical director, I think, at 3 of them, and part of the medical staff at 2 others. And that includes Menard, which is our biggest prison. So he has something like 5,000 patients that he's supposed to be seeing. Even if he was a good doctor, which he not necessarily is, but even if he was a really good doctor seeing that many patients at 5 different sites, he couldn't possibly provide good medical care. Just numbers alone make it impossible. Quite aside from the fact that he has some serious problems in terms of the quality of practice he provides. And working in a prison really sucks. So technical legal term, sucks. So it's hard to attract people. I don't want to say that it's easy to attract doctors. It's not a good place to practice medicine. You know, these old prisons are dirty, they're noisy, they don't get much office space. Your chances of getting a computer at all is not necessarily big. Your chance of having a private office is small. A good computer connection is unheard of. And of course, you're dealing with people very quickly. You know, you may get five minutes with a prisoner in order to figure out their whole life's problems. So even good doctors would have a hard time practicing that situation, which means good doctors don't try. Go to the next slide. And a large part of the problem is not that Illinois doesn't hire people, but that they can't keep them. So as quickly as they hire people, pour water in the top of the bucket, they leave. We had an independent expert do an assessment of why there was such a high turnover rate or why there was such a low retention rate. You can look at it either way in Illinois. And they came back with a number of what I thought were really startling suggestions. Startling not because they're weird suggestions, but because I would think they were obvious. The one that sticks in my mind most is some prisons weren't actually providing toilet paper and paper towels for the staff bathrooms in the healthcare unit. If you're working for somebody who says you got to bring your own toilet paper to work, it gives you a really strong signal that you are not a valued employee of that employer. So that was like one suggestion was, why don't you actually just provide toilet paper and paper towels for all of the staff instead of making them bring it for home? That would probably increase your retention rate. As well as doing things like somebody would get hired on for the evening shift because they had kids they had to take care of during the day, and therefore they could take the evening shift. But the shift you actually got wasn't necessarily the one you got hired for, because seniority gets to pick which shift you're on. So you may have signed up for one shift and you show up for work and they're like, sorry, you're on this other shift. And you say, well, I can't do that other shift because I got childcare requirements. And they say, sorry, that's the shift you're assigned because somebody else in the union took your bid for your better shift because it's a better shift. So you end up with a shift you didn't ever bargain for, and you just quit instead. Often, particularly for mental health side, there's a hostility between the mental health staff and the security staff. Security staff often have told me, we know who the really mentally ill people are, we can tell. But all these other prisoners, they're just faking it, trying to get over on people, trying to get drugs or trying to get special treatment or whatever it is. And these nurses, they just don't know the difference. Their prisoners get over on them all the time. They're way too nice to these guys. And that often leads to some retaliation. So we've had stories where guards have intentionally left a nurse alone with somebody who's dangerous or who's a sex offender, for example. There was a nurse that was raped at one of the prisons by a prisoner when they were left alone without any security staff there. We've also had mental health workers complained that their cars in the parking lot had been keyed. If they pissed off a security officer, somebody would take a key and rip it along the side of their car when they come out. So it can be a hostile work environment. On top of which, there's also underlying racism. Lots of the staff, particularly in the northern prisons who come in, are often from Chicago, want to actually take the job because they want to do some good for the minorities that are locked up in our prisons, and they show up and they're really find out that they're not allowed to actually provide care, that their job is to fill out paperwork, not to actually provide care for people. So they quit. So retention is a very serious problem. So it means you end up with a high turnover, and they're hiring all of the time. They will tell you, well, we don't have a problem with attracting people. We hire hundreds and hundreds of doctors. What are you complaining about? But none of them stay. All right, let's go to the next slide. So what do we do about this? So this is where I want to talk about the law. The Supreme Court, way back in 1976, strongly suggested that because when you lock a prisoner up, you deprive them of the ability to get medical care on their own. They can't find it anywhere. So therefore, the state has a constitutional obligation to treat them because they can't get treatment anywhere else. If you take away their ability to get their own treatment, then you have to provide treatment for them. And doing so, if you don't do that, and somebody's sitting there in pain, then it's no different if you inflicted the pain on them yourself. And therefore, people are entitled to medical care. If you don't, it's a violation of the 8th Amendment. It's a violation of the Cruel and Unusual Punishment Clause. They say that in Estelle, but they also say not every time when somebody doesn't get medical care is going to be a violation of the Constitution. We don't want to constitutionalize medical negligence. So in Estelle itself, the facts there were pretty dramatic. This is in the South. Somebody was unloading cotton bales and twisted his back. Cotton bales are huge. They're like 50 to 100 pounds, and lifting him off of a truck. Messed up his back, went to the doctor, got seen dozens of times. Each time they essentially just prescribed Tylenol and told him to have bed rest and lower bunk and not to work for a while. Guard said, the heck with that. We don't believe you're that badly off. Go back to do your job. So he sued. And the Supreme Court said, well, yes, the government has an obligation to provide you with medical care, but he got medical care. He got seen by a whole bunch of doctors. He got seen 20 times. So how can you claim that he wasn't getting medical care, even though none of those doctors actually made him better? So they were trying. So what has the state done with it? What has the courts done with that kind of problem, that the tension that was there in Estelle? On the one hand, it says you have a right to care. On the other hand, it says, yeah, but it can't just be that it didn't work. So the courts have come up with this sort of 4-part test, and go to the next slide here, which says you have to prove 4 things in order to prove a violation of the Constitution. And I'm telling you all this not because you're going to become lawyers, but so you understand the limitations of what we as lawyers can do. First of all, you have to have a serious medical need, which is defined as something a doctor says need treatment. That's not usually a big deal. If somebody's writing me or somebody's writing their moms, then it's probably because they actually have something wrong with them. If you have a hangnail, you and I would not go to a doctor. We'd clip it out. If you fall down and get a scrape, you put on a Band-Aid. You don't go to the doctor. So not everything needs it. But if it's a serious medical need, something that a doctor would normally treat, then you pass that first test. It's the second one that's hard. The courts have called this deliberate indifference. And what that means is that the medical professional has to have actual knowledge of the problem, and they have to consciously disregard it or consciously decide not to do something that they know would fix it that's reasonable to do. So that's a subjective test. It's about what's in the doctor's mind. And that's where it gets really tough to prove some of these cases, because the doctor, like in Estelle, would say, well, I knew he was in pain, but I certainly didn't know what the cause of that pain was. And I wasn't consciously disregarding the pain. I did something. And giving him pain relievers seemed like a reasonable thing to do. You can't sue me for that. And the court agreed. So it often comes down to this question of whether or not the doctor made decisions for some other reason than medical need. So, for example, he just couldn't care. somebody put something about Anthony Gay in the chat, so I'll use him as an example. When he was at the Supermax prison, he used to cut himself regularly as a sign of his mental illness. And eventually the doctor there said that I am not going to use anesthesia, not going to use painkillers before I stitch you up, because that will teach you not to cut yourself, because you know it'll be painful to get fixed. So that would be a great example of somebody who is consciously disregarding a reasonable thing. Anybody who gets stitches always gets that numbing cream before you put the stitches in because they hurt. You're sticking a needle in your skin. And the doctor down there said, well, in order to dissuade you from cutting yourself, I'm not going to give you any kind of pain numbing agents before I stitch you up this time. And in the future, you just have to live with the pain of being stitched up if you're going to keep cutting yourself. That's one example. There are lots and lots of others. A case that went up to the Seventh Circuit was somebody did in fact have a broken arm. The nurse that was on staff called up the doctor and said, hey, this guy's got a broken arm. The doctor was at a New Year's Eve party, said, I've had like 5 drinks. I cannot come in and provide medical care. I'm half in the weather here. He'll have to wait till Monday, 3 days later. And so the guy sat there through the weekend with a broken arm, which was really, really painful, as you can imagine. And that's, again, not doing something for a reason that's not medically based. It's because he was drinking instead. It's not a good medical reason not to set somebody's arm. So there's lots of those occasions where it's easy, but in most cases, it's not easy at all. And you have to really show that what the doctor did is just so far beyond the pale that no reasonable doctor would have done what he did. The third element is causation. And this is also sometimes a difficult hurdle. This comes up a lot in cancer cases, for example. The fact that somebody did not get seen by an oncologist for 6 months. The question is, if you caught it 6 months ago, was there anything you could do about it? Or was it too advanced 6 months ago? And that's often really hard to prove because he wasn't seen 6 months ago. So how do you know how bad it was 6 months ago? For all you know, it had already metastasized 6 months ago, and there was nothing you could do at that point. So often these cases are very difficult to prove the causation. That is, that the delay or the failure of treatment or the bad treatment he got actually made things worse because he wasn't seen before. So you don't have a sort of before and after to compare with. The first time they got seen, it was really bad, but it might have been really bad if they'd seen him the very first time as well. And finally, of course, you have to have suffered in some way, so happy damages. That part's usually pretty easy. Let's go to the next slide. We've been talking about the IDOC, and I just want to very briefly say that the standards in jails are different. Why are they different? Because prisons are governed by the 8th Amendment, the cruel and unusual punishment clause. But because detainees in a jail have not been convicted of anything, they can't be punished at all. So the cruel and unusual punishment part doesn't come into effect. And it's that punishment thing that gets you to that deliberate indifference standard. That is, punishment suggests by its word that there's some subjective intent. And the example I always use for this is, let's say you have a kid at the top of the stairs. If you bump into your child and they roll down the stairs by mistake, nobody thinks that you punished the kid. You may be a terrible parent, you may be grossly negligent, but nobody said you did this to punish the child. On the other hand, if you pushed the kid down the stairs because they misbehaved, then everybody would say that's punishment. From the kid's point of view, it looks exactly the same. It got pushed down the stairs. But the word punishment suggests that there is some deliberate intent there to inflict pain for some reason. So that's the excuse they use to have this really hard standard in prisons. Because you can't punish anybody at all in jails, you don't have to have quite such a hard standard. So the standard in jails are that the defendant has to act in purposely. So it can't just be a mistake. So the old example of a surgeon leaves a sponge in somebody's stomach while they're closing up. That would be pure negligence. No one would suggest that the surgeon deliberately left the sponge in there. It was just an accident. That's not going to get you a constitutional claim even in jail. But again, it does not have to be for the purpose of inflicting pain. It just has to be an intentional act. It has to be more than negligence, but not a lot. And you don't need subjective intent. So intent to inflict harm. So it's an easier standard, but not all that easy. It's still not a negligence standard. So it's still not the same at all as medical malpractice. It's just a little bit easier. All right, so that's the, on the other hand, if you have a case which meets all those things and there's real damages, then there are a lot of lawyers who take on these cases. But I emphasize you have to have a significant damages. All of these cases require us as lawyers to hire an expert, and those are not cheap. So that's often why a lawyer won't take a case about medical care, because in order to figure out whether they even have a case, they really have to pay an expert to look at the rules, look at the medical records, and come up with an analysis. You know, is this doctor just negligent, or are they so far out of the ballpark that you actually have a constitutional case? So without some serious injuries or a death, it's often hard to find lawyers who want to take these cases on, which is one of the reasons we're trying to do it as a class action case, where we're not trying to get money for anybody. We are just trying to fix the system, to get rid of things like the copay, get rid of things like the peer review, trying to increase the number of doctors, the quality of care, all those sorts of things on an injunctive claim that is trying to make things better in the future, rather than trying to prove that a particular doctor had bad intent. So that's kind of why we switch from bringing individual cases to try and do this class action stuff. The individual case is really hard to bring. All right, so you can't just call a lawyer and solve all your problems. So what can you do? Let's go to the next slide. There are some people you can try contacting. And advocacy is the best remedy. I would say in general, the more people who contact the prison system, the more likely you are to get some results. But frankly, the very fact that anybody is contacting the prison system puts you ahead of everybody else. Just because so many people are in prison without any outside advocates whatsoever. And it's really easy to ignore those people. As soon as they know that somebody from the outside is contacting them, it's very likely not necessarily to solve the problem, but at least get a little bit of attention to the problem. So there is now a family liaison officer, and they can be reached by mail or phone or fax. This is all on the IDOC webpage, so you don't have to write this down. It's on the website page of the IDOC. As I think Julie said, you'll be getting the slides anyway, so don't try to take notes really quickly while the slide is off. You know, I have heard reports that this can be useful. I don't know if other family members on here have different experiences, but I've certainly gotten reports back that not necessarily that it solved the problem for the prisoner, but that after they call, somebody like a nurse or a doctor or somebody sees the prisoner and at least sees them. Even if they don't do what they're supposed to do, they at least get seen. Let's go to the next slide. It's also good to have a medical release if you want to talk to anybody about what's going on with your loved one. They cannot talk to you at all unless you have some release. There's again an IDOC form which is on the website. I've given the authorization. I've given a copy of it on the left here. That has to be signed by the prisoner. And by the way, there are separate releases for medical records and mental health records. There's two separate releases. If you have one of those, though, it does not mean that the medical staff has to talk to you. It only means they can talk to you. So we get complaints all the time from family members saying, hey, I got this release. They refuse to talk to me. They can do that. It's only an authorization for you to talk, not a command that they talk to you. They can still say, sorry, we don't deal with family members. But without that piece of paper, they can't talk legally. They're not supposed to tell you anything at all. So it's always a good idea to have it, but understand it may or may not do the trick for you. Let's go one more. The other thing that people are often complaining about is the power of attorney. So I got a power of attorney for my son, so they have to talk to me. And the answer again is no, they don't. It helps. Again, it's a good thing to have. But legally, those things only go into effect if your loved one is disabled, so they can't make decisions for themselves. In the absence of a power of attorney, by law, the warden is the one who gets to make the healthcare decisions for a prisoner. So if there's no outside person, then the warden has the ability to authorize any medical procedures that they feel are warranted, which basically means anything the doctors want, because the wardens aren't about to overrule the doctors. So it's good to have that power of attorney in case something does go wrong with your loved one inside, but it's not like a magic wand that forces them to talk to you if your loved one is still competent. And the final thing is, it doesn't give you any more rights than the prisoner would have themselves. So you can't like demand things that if the prisoner demanded them, they could say no, just like they can say to you. So it doesn't give you more rights than the prisoner has just because you're an outside person. But again, it's a good thing to have in your back pocket in case something really goes wrong. But it is not going to solve all of your problems. One more page. So the healthcare unit administrator, as I said, they don't actually have the power to order IDOC to do anything, but they do have the power to schedule people for appointments. So often if you call somebody, the healthcare unit administrator, call the prison, ask for the healthcare unit, talk to the administrator and say, hey, my son has not been seen for 6 months. He's complaining about, he's been on a hunger strike, or he's complaining about a cough, or whatever it may be. Then again, often, not a guarantee, but often that will spark the healthcare unit administrator to contact a doctor and say, hey, let's schedule this guy for an appointment. Family members are being a pain in the neck. At least we got to see this guy. I'm not going to tell you what to do, but can you at least go see him or have him brought over to see? So that can help. Similarly, if you have a friendly legislator in your district, they all have like liaisons who deal with the Department of Corrections. If you can get a legislature to call up their liaison in the Department of Corrections, that also will get their attention. So again, it's another way to try to get somebody's attention. It's not necessarily going to get them the help they need, but at least they can't then say, hey, it's impossible. We don't know anything about this. Nobody told us about it. They're on notice that there's a problem. And remember, that was one of the criteria for bringing a constitutional claim, was they had actual knowledge of the problem. So on the one hand, the courts are given an incentive never to find out about problems, because once they know about it, then they have an obligation to do something about it. But if they never learn about it, then there's no obligation at all. So your calling can at least get if it should get to the point of a lawsuit, get you over that first hurdle of, do you have actual knowledge? Yeah, I called up the prison and told them about it. So they clearly had actual knowledge. And of course, if more people call about it, the more likely to get attention to it. Again, they really are. I mean, I've seen those internal emails. If somebody calls anywhere, then generally there's an email generated saying, hey, so-and-so's mom is calling the prison, what's going on? So you may get a response of some sort. They may not get back to you at all, but they're likely to get to your loved one inside. Let's go one more. Also hard to get a hold of is the agency medical director, but you can leave messages. Currently it's Steve Bowman. Again, he does not control Wexford. He cannot order them to do anything. But he can make calls, and usually, again, a call from the medical director will get somebody to see your loved ones. But I emphasize, paying attention to the problem is not the same as getting the actual treatment. Wexford still has a huge incentive not to send people out for treatment. Remember, it's a for-profit corporation. So if every time they provide care to somebody, or particularly by sending them outside, it's money off the bottom line, off their profits. So in some sense, they have an ethical duty to minimize the amount of care they're providing, and in order to maximize the value to the stockholders. And that is the problem with privatized medical care, is that their first duty is to maximize profits, not to provide good medical care. Now, sometimes those two things overlap. In theory, anyway, they should be able to get bigger paying and more contracts, the better care they provide, but it doesn't always work out that way at all. And sadly, Illinois has just re-upped the Wexford contract for an additional 10 years, despite the fact that they've been sued hundreds of times and have generated thousands of complaints about how bad their care is. Nonetheless, the state has decided that they're entitled to another 10-year contract. So we're going to be dealing with Wexford for another 10 years. And I think that's the end of the slides. And what I've gotten in was just how you get a hold of, how you can find out more about the Uptown People's Law Center. So,
Hey, Alan, I put a question in the chat. I'm not sure if you were able to see it.
nope. There's other people here running the chat.
Oh, sorry. With the current
Yeah,
situation with
we're gonna get to the questions in the chat in a moment. Thanks.
Go ahead, Heather. She can go. Oh, are you there, Heather? Yeah, go ahead with your question.
Sorry, I just with the current state of the fentanyl overdose and the 20 men that have been shipped to the 4 hospitals in the past 48 hours, I have somebody on the call with me they're not letting the families be aware of the overdoses or the 4 hospitals that they've sent them to.
Yep.
Can we maybe just do a call to action or next steps in the chat for that situation? Sorry to interject.
No, and this also, it's a good point. The IDOC has no obligation to, and they have a policy of not generally allowing family members to know if somebody gets sent out to an outside hospital. Again, the theory being security, that if you knew where they were, it'd be easy to break them out because, of course, security is much lower in a hospital than it would be behind the walls. So for security reasons, their position is they don't tell people when they're being, the same reason they don't tell you when they're moving them from one prison to another in advance. Just like they don't tell you when they're transferring somebody, or at least where they're transferring to, they also don't tell you when they're in the hospital. So yeah, this is a very common problem. Sometimes we as lawyers can get that information if we are already representing them, because we have to be able to talk to our clients sometimes, particularly if it's going to be longer term inside. Sometimes the legislature can get that information from them, but this is something that they guard pretty carefully and don't want to give out to anybody outside for security reasons. At least that is their rationale. And I will say, I agree, there has been a increasing drug problem in prisons. I've talked to a lot of prisoners who are complaining that they feel unsafe because half the prison population is walking around stoned all the time. And they view this as a serious problem. Unfortunately, from my point of view anyway, the department's reaction has been punitive. In general, they're charging people with possession of contraband, drugs or drug paraphernalia, and putting them in solitary or revoking good time. What they haven't done is start a whole bunch of drug treatment programs, which would seem to me the obvious problem, or the obvious solution. If you have a bunch of people who feel like they need to take drugs, you should figure out why. They're not cheap inside. Rather than punishment, which is unfortunately the same thing we do on the outside. On the outside, we're all about police and interdiction of drugs and stopping immigrants from coming to the country and all that kind of, and of course, locking people up for drugs and not.
I can't hear anything.
Alan, I
I
think
think
we have an issue with your speaker or your microphone.
Ah,
Hello, Alan. Hello.
uh-oh. Yeah, we're here. We're just.
Oh, you're here. I just had a question for the
Oh,
medical.
we admitted Alan again. Hold on. Just okay. We admitted Alan somewhere.
Oh no. For the medical release form, does a new one have to? How long is it good for? And does a new one have to be filled out at each facility?
Looks like we lost him.
You right now, Alan. Hold on. He's there. He's just
All right.
ask Alan. There we are.
Can you hear me now?
Try. Yes. Okay.
It shouldn't have to have a new one for each facility, and it should be good until whatever at the bottom of that form is a line which says this is good until so and so. I always fill those out saying it's good until the prisoner is released. But if you put a particular date in, then of course you need a new one whenever that date happens.
Okay, so we're going to get to some of the questions now that we monitored in the chat.
Yep. The first question I saw come through was, how quickly should they be responding to sick calls?
The policy is within 24 hours, but that is not, they don't have enough doctors, so it often doesn't happen. So again, it is like a triage. They prioritize the more serious, at least in theory, again, they prioritize the more serious cases. Just like when you go to emergency room, you may be the first one there, but you may be the 100th person to see if everybody else comes in after you has a more pressing concern. So there's not the goal is 24 hours, but that is not going to happen in most prisons today.
Great. And next question was, can they fill out the sick call form more than once a day?
Generally, no. There is an unwritten but pretty firm policy of one problem per visit, which means that whatever you signed up for on your sick call is the only thing the doctor will talk to you about. So you may have signed up with a sore knee, but you've also got this sore back problem that's been going on forever. And if you want to try to talk about both of them, they'll probably say no. Why do they have that policy? Well, the stated reason is in order to avoid prisoners manipulating the system. So they don't want somebody to be able to sign up and say, I've got a broken arm, and which would immediately get you taken to the top of the list. And then you get over there and say, well, what I really needed was a Tylenol because my wrist is sore. So the theory is they do it in order to avoid manipulations of the wait list. But the reality is that as the result of this is that there's no one doctor who sits down and says, all right, these are the 10 different things that's wrong with this person. We need to come up with a coordinated plan to deal with the whole person. And that is the downside of this policy, is they never do that.
Right. Next question is, can I ask the counselor to make an appointment for my loved one?
I mean, I suppose you can ask, and I suppose a nice counselor might, but that is not at all the usual way you get to the healthcare unit. Again, the counselor might call up the healthcare unit and say, hey, mom called, or is somebody paying attention to this? But that's not a guarantee of anything. But again, if that's the only person you get a hold of in the prison, talk to them.
If one is able to find out the email address for medical staff or prison staff and sends one of them an email about an issue in order to prove receipt, can one get in legal trouble for doing that?
Nope. Go for it. I mean, assuming you didn't steal the email address.
Can you please help clarify who hired
give
Wexford?
a little hint on emails. I don't know in the prisons, but I will tell you for most of the prison director staff and stuff, typically it's the last name dot first name at illinois.gov.
It's a good guess, right?
So I always try that. Why, Alan?
I said that's a good guess. It's a good place to try. If you don't have no idea where you're trying,
Yeah.
Give it a try.
Yeah, so that's pretty much their, a
But
kind of a
remember,
standard.
not all the staff have email accounts. So
Right, and I don't know inside the prisons if you would know, their first and last name. A lot of times, it's just officer so-and-so, so but might work with some of the director's staff. Not that I said that.
not that you ever tried that, but
Right, exactly.
That's a good tip, Julie. Thank you. Next question was, can you please help clarify who hired Wexford? Have been getting the runaround from legislators as to who is actually responsible for giving them a new contract.
yeah. So Illinois has a long history of corruption, as you may be aware, including in issuing these medical contracts. In fact, the former director of the Illinois Department of Corrections, Donald Snyder, was prosecuted by the federal government and sent to prison for taking bribes in order to give out, not from Wexford, a medical contract a couple decades ago. So in order to avoid that sort of corruption, the state has set up a quite complex, allegedly objective process for giving out all state contracts. And that requires the IDOC to come up, and really it's the medical director, to come up with a list of criteria. So what in the bids are going to be given how many points? Then they put it out for bid. Anybody who wants that contract submits a sealed bid. The Department of Corrections opens them. Or not the Department of Corrections, CMS, the Central Management Services, opens them, grades them based on the criteria that the IDOC and the CMS have agreed to together. And then the person who gets the highest grades has an option of taking the contract. So that's what they did. I don't know what those criteria were. As I've always said, it's obvious, however, that they didn't weight actually providing good care to prisoners highly enough. or they never would have given Wexford the contract again. Wexford was not the low bidder. Somebody else was, but they nonetheless got the contract.
Does the person who is incarcerated receive a copy of the SOAP or SOAP form after their visit?
No. They have the right to request a copy of their medical records, but it's not automatically given to them. And they can charge you for that.
Do you know how much they could charge you for it?
No more than the cost, and I know there's a statute out there which says how much they can charge, but I don't remember what it is. I want to say it's a nickel a page, but I'm not sure that's right.
Okay. Next question is,
What
what
do
about,
you need?
oh, sorry, go ahead.
I was gonna say, wouldn't you need something like that if to show that they didn't?
Absolutely.
I mean, if you ever went to,
If you go to court, you definitely are going to need a copy of their medical records.
and they could possibly lose it if you didn't have a copy. Okay, sorry, Lizzie, I just kind
You're a little cynical there.
of, it shows.
I mean, there is a state law that says they have to keep records, so they're violating law if they don't, but that doesn't mean it doesn't happen.
And they really could lose it because it's not on a computer, so. I
Yeah,
mean,
computers can crash too.
unintentional. That's true, that's true. Sorry, Lizzie, go for it.
Nope,
I know
no
you got a lot
worries.
of questions.
No, the chat is very active. It's great. What can be done about regular malpractice, for example, when the medical team is treating the wrong problem?
Yeah, I mean, there's always the option of filing a regular old state medical malpractice claim. The problem with doing that is that Illinois requires, before you can file such a suit, you have to have an affidavit from a doctor saying that he has reviewed those records and they have concluded that there is at least a good reason to believe that the doctor was not operating by the accepted standard of care. So really that means that prisoners themselves are going to have a very hard time doing this. How are they going to find and pay a doctor, an outside doctor, to review these records? And it's not cheap. I mean, you're talking about a couple $1,000s to have even a simple record review. And you have to have that before you can even file in court.
Is medical only for severe cases, or do they supply meds for sinuses, cold, flu, allergies, etc.?
Some of that, it depends on the prison. Some of that stuff you can get from commissary and treat yourself. I know at TAMS, for example, you even had to go to the doctor in order to get Tylenols prescribed. So it depends on the level of security of the prison and what they're willing to sell on commissary as compared to what you have to have a doctor say. But in general, I would say they deal with everything. The problem is something like a cold or sinus clogs or allergies are likely to be given low priority. And often by the time you get to the doctor, the problem will have cured itself.
I think those are all the general questions we have for now. I will pull the slides back up and hand it over to you, Julie.
Okay, cool. Yeah, we'll just perfect timing. I as often when we report a lot of this, we kind of went through this. You can try the healthcare unit administrator. Alan said the same thing. I actually put the agency medical director, the Springfield number. I didn't put down my guesstimate of an email, but his name is Stephen. And we talked about constituent services, and I know it's frustrating for people. They get a lot. I still urge you to contact them, email, because I think you need that record and we need those records. Constituent services is supposed to do an annual report that shows what kind of complaints they got. We're pushing them to make the report a little bit more complete. Nothing in the Department of Corrections moves quickly, but it's very, very important. So I would urge all of you to reach out to constituent services all the time. And as Alan said, just having someone on the outside do that, you're ahead of everyone else. So next slide. Additional questions, there's Alan's email. Yay.
I
There's my
volunteered it.
email.
You didn't have to guess at it. I volunteered it.
Yes, yeah, we have it all over the place, but just so you know, if you have some questions and you want to shoot them an email, and we'll try to get back to you with whatever we can. Okay, next slide.
And just to be clear,
This
we cannot solve all those individual problems. To be clear, we get something like 75 letters a week from prisoners, so we can respond to them all, but that doesn't mean we can actually intervene on everybody's behalf, or we would do nothing else. So.
And the thing is even doing these trainings we've done is just to try to help loved ones navigate the system a little bit better. It's a big monster of a system in Illinois. There's a lot of moving parts. And I wish I could solve all the problems. But I will say, just kind of attending things like this, whatever you can find out, and talking to your legislators and calling the facility and constituent services. We are working on our workshops for 2025. We had transfers in the DOC this year, and a lot of things were referred back to programs. The chief of programs is Jennifer Perrick. I've been in touch with the DOC. She's very busy now because of transfers with Stateville and Logan, but we are going to get her on a call. You'll all be invited to learn about programs in the Department of Corrections. And we're also going to have the new liaison for the constituent services next year on one of our calls. If there's any ideas or issues, please shoot me an email or something. That we do about 6 a year. So let me know what you'd like to know about. Next slide. Is there any more? Okay, here's what we have also, what we did this year. And I still have the medical issues with September. So I somehow messed up my months. But anyway, these are the things. We were welcoming our loved ones home. The guide to transfers, which was that we don't have that recorded because the Department of Corrections transfer coordinator was on there. And we don't record when we talk to the Department of Corrections, but we did take notes, and we're happy to send them. Higher education in prison, how to fill out a FOIA request, and grievances. And then September's is medical issues. I just can't get the month straight. And you can email Lizzie, or you can click and get them when we send you the slides. Next slide. Hurry. I'm going to let James just kind of talk about this slide, because he is our policy manager. James, are you here? I'm calling him out.
I'm here,
He's not here.
Jules. Yeah, I'm here. You know, I was ready for you to do something like that. So this is just literally just a slide letting you guys know our upcoming trainings. These are our fall quarter trainings. We try to do 4 trainings each quarter. So we have 2 virtual and 2 in person. So that's basically all that is. You can also find all this information out on the website if you want to dig in and find out a little bit more about what each training consists of. But we do 2 trainings, one on Advocacy 101, basically just giving you the process of how a bill is made. And then we come behind that and do a building relationships with legislators. We kind of give you keys and gems after we show you how the process is done to kind of like get your foot in the door and have your voice heard. So back to you, Jules.
Next slide. And we'd love for you to join. This is kind of you too. Our
Yeah, that's why I
team.
just laughed. So the advocacy team is something that we do at Restore Justice. It literally starts when session starts from January to May, and we usually start around February once things gets going. But this is something that we do on Fridays during the regular session from 12 to 12:30. And all we do is just give updates on what's going on in Springfield with our legislation, other pieces of important legislation. We talk about it all. So if there's something that you would like to see us talk about or would like to learn, we always encourage individuals to come to that. And depending on where we're at with our legislation, we may have tasks for individuals to do. You know, we have a template to where people can fill out a letter in support of what it is that we're doing or an issue specifically to their legislators. We kind of like make sure that individuals have that thread and knowing who their legislators are so their voice can be heard. So if you feel like that's something that you would be interested in, you can go to restorejustice.org and fill out for that and join us in this upcoming session.
Thank you. And thank you all for coming, for caring. And thank you, Alan, for really sharing your knowledge and for like the fact that sadly we can't fix it, but at least you're more knowledgeable. Wish we could fix everything. Alan, when some of the things he tells me, and my son was in for 27 years, and I just still am like, what? But I really do. Thank you so much. And thank you for, just kind of laying it on the line the way it is. And we really appreciate that.
I always appreciate coming, and I'm glad you still have that reaction. If you didn't, I would worry about you because the stuff is horrible. So you're supposed to be horrified.
Alan, you have somebody
in
the chat that's asking, can they make an appointment with you? And I think he'd be happy to receive an email to maybe try to schedule something like that.
Yep. Send me an email.
Yeah. We're thank you everyone for joining us and taking some time out of your evening. And we'll talk to you soon. Bye.
All right. Thanks, everybody.
Thank you, Alan.